the object of the Act is to provide an expeditious remedy. And the last 3 lines of paragraph 3 of my submission, my lord. If courts exercise the power to modify the award, it will eliminate the formality of going back to a new tribunal to reaffirm a conclusion which has already been reached by the court, thereby ensuring an earlier quietus to the dispute. This, my lord, forms the basis of, my lord, the guardrails that I would be submitting for your lordship's kind consideration. My lord, the point has already been made that in section 34, it is only 34(2)(a)(4) that expressly contemplated partial setting aside, to the extent that the award is severable to that extent. But your lordships have read that power to encompass all of 34, not limited to 34(2)(a)(4). That is the judgment in JG Engineers and the recent Delhi High Court decision in Trichy, Tanjavur. But in addition to what has been submitted on that point, your lordship may note, my lord, in the Delhi High Court decision, there is a reference to the earlier versions of the model law that specifically contained a power to partially set aside an award. Those earlier versions did not find place in the final model law. Notwithstanding that, your lordships have found that where an award is severable and it does not impact other aspects of the award, that part of the award may be set aside. Even though, my lord, the earlier versions of the model law had a specific clause, which clause was not contained in the final. That's, my lord, only additional submission. And the reason your lordships have done that is, my lord, again, to make the Arbitration Act workable, to ensure expeditious dispute resolution, and to say that where an award consists of severable disputes, then to the extent of that severance, a part of the award can be set aside. And your lordships have gone one step further, my lord. Your lordships have said it should not even be only textual divisibility, but even substantial severability is okay. Because normally, my lord, the rule of severance was, or severability was, can your lordships draw one line through the offending part of the line, a part of the clause or the award. Your lordships have said we're not looking at it as textual divisibility, but substantial severability. Because, my lord, the argument I think that has found favor with your lordships is parties have subjected themselves to arbitration. An arbitral tribunal has correctly decided claims 1 to 5, but claim 6 is liable to be set aside on some head or some ground. That can be severed only to that extent the award can be set aside. And in that sense, my lord, I adopt Mr. Khambata's submission that partial modification, partial setting aside is also modification. Ultimately, your lordships are reading section 34 and saying, although it talks of setting aside an award, your lordships are saying an award is an agglomeration of various claims. And one part of that award, to the extent it can be severed, can be set aside. Well, paragraph 5, I make the point which your lordships have already seen, my lord, that even in Hakim, where your lordships found there is no power to modify the award, the modification was upheld, only showing, my lord, that this is perhaps a need for the arbitration ecosystem. My lord, if I may just place 1 or 2 paragraphs of the judgment in Hakim. If I may place only 1 or 2 paragraphs in Hakim, this is in the common compilation, page 11. Mr. Dattar's compilation. The very first compilation.
Written on it. Compilation written.
So the judgment starts at page 11.
Yes, please.
Do my lords have it, my lord? Page 11. Well, the judgment in Hakim initially, my lord, proceeded on the basis that earlier judgments of this court had already held that there was no power to modify. And in that regard, my lordship may have paragraph 25 at page 27. Paragraph 25. As a matter of fact, the point raised in these appeals stands concluded in McDermott International versus Byrne Standard, where this court held, and your lordship may come directly to paragraph 52 on the next page of McDermott. The 1996 Act makes provision for the supervisory role of courts for the review of arbitral award only to ensure fairness. Intervention of this court is envisaged in a few circumstances only, like in case of fraud or bias by the arbitrators, violation of natural justice, etc. The court cannot correct errors of the arbitrator. It can only quash the award, leaving the parties free to begin the arbitration again if it is desired. So the scheme of the provision aims at keeping the supervisory role of the court at minimum, and this can be justified as parties to the agreement make a conscious decision to exclude the court's jurisdiction by opting for arbitration as they prefer the expediency and finality offered by it. So, this observation in McDermott, where really the issue of modification did not arise, was the starting point of the analysis in Hakim as to why the courts cannot modify an award. And then, the lordships, also referred to Kinari Malik, which again, was a case under 34(4) and didn't squarely raise this issue. After finding, at paragraph 41, at paragraph 42 at page 38, paragraph 42 at page 38. Is my lord the Chief Justice have it?
Yes.
Para 40. It can therefore be said that this question has now been settled finally by at least 3 decisions of this court. Even otherwise, to state that the judicial trend appears to favor an interpretation that would read into 34 a power to modify, revise, or vary the award would be to ignore the previous law contained in the 40 Act, as also to ignore the fact that the 1996 Act was enacted based on the UNCITRAL Model Law on International Commercial Arbitration 1985, which, as has been pointed out in Redfern and Hunter in international arbitration, makes it clear that given the limited judicial interference on extremely limited grounds, not dealing with the merits of the award, the limited remedy under Section 34 is coterminous with the limited right, namely either to set aside an award or remand the matter under the circumstances mentioned in 34 of the Arbitration Act. Similarly, the court proceeded on the basis, my lord, that there is a limited right conferred in Section 34. And it is that limited right that leads to a limited remedy. A different articulation, my lord, is in the impugned judgment in Gayatri Balaswamy, my lord, the lead matter. Justice Ramasubramanian, as he then was, my lord, says that the remedy cannot be worse than the malady. That's how he puts it. And that is, my lord, in my respectful submission, the issue your lordships are deciding today. Whether 34 is a limited right that therefore gives rise.
There is a way of interpreting 34(4).
Yes.
If we accept there is an implied power or subsumed power of a lesser relief,
Yes.
34(4) can be exercised where the court finds it difficult
Yes.
to exercise that power.
Yes.
Say in a case where documents are not produced.
Correct.
Or hearing is not granted and award is passed. Or otherwise you find that it's not possible to segregate and divide. Then in that event, the court can exercise that power. That's an argument in your favor.
Yes.
The other side can argue the other way around and says the entire power of modification is subsumed in subsection 4 to 34.
Yes.
But you can argue that this will not curtail the power of the court, where they can correct the correctable errors.
Yes.
By the court itself.
Yes. But
curable errors by the court itself.
I'm deeply obliged, because that was my next submission. The argument raised against us is that 34(4) contains the power to modify, and therefore when the Act expressly contains one method to do this, no other power can exist. That's
That's the argument against you.
Yes, that's the argument against us. Well, the power under 34(4) is very different from the power of modification that we are requesting your lordships to find that the court will exercise while entertaining an application for setting aside. May I, my lord, place one decision of this court, but first, my lord, may I just place 34.4. The submission is this, that perhaps 34.4 is being misconstrued as conferring a power on the arbitral tribunal to modify its award. The scope of 34.4, my lord, is only for a tribunal to cure its defects of reasoning, not to change the end decision of the award. But may I place 34.4 and then the decision in IPA clearing? 34.4, my lord, on receipt of an application under subsection 1, the court may, where it is appropriate and it is so requested by a party, adjourn the proceedings for a period of time determined by it in order to give the arbitral tribunal an opportunity to resume the arbitral proceedings or to take such other action as in the opinion of the arbitral tribunal will eliminate the grounds for setting aside the arbitral award. And now your lordship will have, my lord, IPA clearing, which is in volume 4, my lord, of the Learned Solicitor General's compilation. Volume 4, 2063. Yes. 2063. But my submission is that this is not a power that allows the court to revisit its award or modify it. That power, if we are right, Lord, lies with the court in certain narrow guardrails. But this is not an opportunity, my lord, for a court to, my lord, send the matter back to a tribunal to revisit its conclusions, to revisit its decision. Your lordship will get that, my lord? 2063, does my lord have?
Yes.
Yes. At 2072, my lord, the judgment discusses an earlier judgment in Dyna, para 34. In the judgment in Dyna Technologies versus Crompton Greaves, it was a case when there was no inquiry under 34.4 of the Act, and in the said case, this court held that the legislative intention behind 34.4 of the Act is to make the award enforceable after giving an opportunity to the tribunal to undo the curable defects. It was not a case of patent illegality of the award, but deficiency in the award due to lack of reasoning for a finding which was already recorded in the award. In the very same case, it was also clearly held that when there is complete perversity in the reasoning, then the same is a ground to challenge the award under 34.1 of the Act. And then if your lordship has para 38. In absence of any finding on point 1, as pleaded by the respondent, and further, it is their case that relevant material produced before the arbitrator to prove accord and satisfaction between the parties is not considered, and the same amounts to patent illegalities, such aspects are to be considered by the court itself. It cannot be said that it is a case where additional reasons are to be given or gaps in the reasoning in absence of a finding on point number 1, namely, whether the contract was illegally and abruptly terminated by the respondent. Further, section 34.4 of the Act itself makes it clear that it is the discretion vested with the court for remitting the matter to arbitral tribunal to give an opportunity to resume the proceedings or not. The words "where it is appropriate" itself indicate that it is the discretion to be exercised by the court to remit the matter when requested by a party. When application is filed under 34.4 of the Act, the same is to be considered keeping in mind the ground raised in the application under 34.1 of the Act by the party who has questioned the award of the arbitral tribunal, and the grounds raised in the application filed under 34.4 of the Act. Merely because an application is filed under 34.4 of the Act by a party, it is not always obligatory on the part of the court to remit the matter to the arbitral tribunal. The discretionary power conferred under 34.4 of the Act is to be exercised where there is an inadequate reasoning or to fill up the gaps in the reasoning in support of the findings which are already recorded in the award. But I'm placing emphasis on this, my lord, to submit that the power under 34.4, if the court exercises in its discretion to remit the matter to the tribunal, which otherwise had become functus officio, is not to, my lord, reverse its findings or modify its findings. It is only to, my lord, give reasoning in support of its findings. And that is why, my lord, 34.4 operates in a different sphere than the modification power we are seeking, my lord, that the court has while hearing a setting aside application. My lord, last paragraph, paragraph 41. Under the guise of additional reasons and filling up the gaps in the reasoning, no award can be remitted to the arbitrator where there are no findings on the contentious issues in the award. If there are,
We have seen that.
yes. So, my lord, that's the submission, my lord, on 34.4.
It's not a power, it's not, certainly not a power of absolute uh, rewriting or anything like that. It's certainly not also restricted, limited to the extent probably is indicated here. It depends upon the factual matrix of each case. It will depend upon the issue raised.
Yes.
Suppose some document has not been looked into as a result, or some document is been overlooked or wrongly quoted, or even the ex parte order has been passed, and whereas the notice was not served.
My lord, I'll make this submission, my lord, only as an officer of the court, my lord. I believe that would then be conferring some kind of a review power.
Anyway, we are not concerned
the
primarily with particular.
But my lord, therefore, the submission is limited only to saying that 34.4 is not a bar to find.
It's not a power of absolute review. There's no doubt
Yes.
about it.
And-
Review power, if conferred, is fine,
Yes.
but not absolute review.
Yes. It's not, my lord, an opportunity for the tribunal to again arrive at a different award. If, for example, my lord, evidence is not considered, then, my lord, that may perhaps be the end of the matter as far as that arbitral tribunal is concerned, subject only to your lordship's power or a court's power under 34 to modify or set aside the award. Because otherwise, my lord, we would be conferring on the arbitral tribunal a power to revisit its award, which I don't believe, my lord, the power is under section 34.4. But the limited submission I was making, my lord, was in response to the submission that since section 34.4 is there in the act, there is a power to modify in the arbitral tribunal, and therefore there is no power to modify in a court. I was therefore, my lord, distinguishing the power under 34.4 from, my lord, the power under the power that we are seeking, my lord, the court exercise.
Mr. Ripinrai, don't you think you're putting it in a very narrow perspective? The power under 34.4, if you go by the language, is not conditioned by so many limitations as you are putting on there.
Yes. Well, Lord, if it were, I appreciate, Lord, this may be too narrow, but Lord, in my respectful submission, a power that allows the tribunal to revise its award.
Not review the order,
Yes.
but it says eliminate the grounds for setting aside the arbitral
Yes.
award. So if the grounds are identified and thereafter the party makes an application,
Yes.
is there any limit on the power of the arbitral tribunal to set aside those grounds which have been indicated, suppose in the order
As your lordship put it.
passed by the 34 court and highlighted in the application filed by the party?
Yes.
Why can't the arbitral
As your lordship put it,
tribunal
Lord, if there are
set aside
certain
those
grounds that will address, my lord, the invalidity of the award, those grounds can be the matter of an application and then a reference to the arbitral tribunal. But in that application, the arbitral tribunal cannot review its earlier decision, is my respectful submission. And that power does not mean that the court cannot exercise the modification power that we are seeking to place and house in section 34.
Again, not to the extent of a review.
I'm sorry, what?
Even the power of modification there would not extend to the review of the award.
Yes, and it would not extend to a review of the award. Well, on my last submission before I...
Then what is the meaning of this power, Mr. Rai? Suppose a document is not put,
Yes.
and if the court wants it to send back to the arbitrator 34.4, and if the necessary consequence will be that we don't know what the arbitrator will do after seeing that,
Yes.
after receiving the answer to that document.
Yes.
So is it an empty power then?
Well, that's why the power is, in my respectful submission, quite curtailed.
Ultimately,
Because
you
your
say the
lordship,
award has to be intact.
yes, because your lordship will see that will then open an entire new chapter. If the arbitral tribunal...
Right, probably, just like there be curable defects or issues or curable incongruities emerging in the award which the court
Not affecting the substance.
similarly, there can be, in fact, the power of curable to cure the defects with the arbitral tribunal may be larger. Maybe larger. They may be larger than what is with the court. Because the court can only do so when it's possible to segregate.
Yes.
But the court finds it's not possible to segregate, it can exercise that power. 43, if one has to go for fresh arbitration, it's almost a
It's a
de
clean slate.
novo,
It
it's
starts
a
over.
de novo.
No, your lordships are right. The power of
And
modification.
then it will be virtually like a power of remand, and the power of remand which is exercised by the courts is also now be frowned upon as long as the appellate court itself cannot decide the issue.
Your lordships are right, my lord, because in section 34, my lord, and I'll just come to that after one more submission, my lord, the guardrails are that the court will not review the case on its merits. So
That's fine.
within the confines. So therefore, it is
No.
narrower in that sense.
Correct.
It is narrower in that sense, my lord. But your lordship may also countenance, my lord, once an arbitral tribunal has rendered its award, to remit in that sense in 34(4), for it to re-examine certain evidence.
Can we
that
now
is-
put a simple question? Can we now formulate? The court's power to cure the defects must be such for which they can segregate, divide, and cure the defects without affecting the substratum and the core of the award, without affecting the substantial substratum of the award, so as to segregate the invalid parts.
Yes.
In case of 34(4), where the court finds itself that will not be possible to do so, then they can remit the arbitrator cure the defects. The defects should be such which can result in the award being set aside on the grounds which are mentioned in subsection 1 and 2. Sorry, subsection 2.
Yes. And
2
my
and
lord,
2A.
my submission is that this extends to all of 34, not just, my lord, the head of patent illegality. But,
Obviously, it will-
but my lord, my lord, I'm only placing this in 34(4). I ask myself, my lord, can an arbitral tribunal change the decretal part of the award? And in my respectful submission, my lord, that far it cannot extend.
Are you contradicting
Let's
yourself?
start by this provision which says that the party making the application was not given a proper notice or was unable to present his case.
Yes.
In such a situation, if that party is given an opportunity by sending him back to the arbitral tribunal,
Yes.
so the arbitral tribunal is now allowing this person to come forth with his case.
Yes.
Will it not have the power to review what it said earlier?
My lord, that would be a ground then to set aside the award.
No. Even in fact, let's put it, Greenland's Bank is very clear. The power of procedural review is inherent in every court or tribunal, whereas power of substantive review is not. And
Yes.
procedural review means where you have not served proper notice, proceeded ex parte, and made some mistake which renders its procedurally wrong.
Yes. My lord, the way, my lord, your lordship may consider the example, my lord, that was just given to me, my lord. The party making the application in your lordship's example would then be making the argument that the applicant in the section 34 has not been given an opportunity of being heard and remand or send the matter to the tribunal. So, my lord, the party is not seeking on its own as to why the matter should be sent back to the tribunal. The party is making an application almost on behalf of the opposite party. And that may be, my lord, extending 34(4) too far. The party that comes in a 34, my lord, challenges the award.
This is the party who's making the application.
My lord, yes,
Go by what 34(2)(3) says.
yes,
Party making the application was not given proper notice.
yes,
Or was otherwise unable to present his case.
yes,
The applicant who's complaining
yes,
that he wasn't allowed to present his case.
yes. That is,
So this provision would be available to the 34 court. All right, go back,
yes. It would
make
be
an
available,
application
my lord,
to
to
the arbitral tribunal.
yes,
Therefore, in such a situation, the award can always be reviewed.
yes.
Why not?
It would be available to the 34(4) court on an application or request by one of the parties. In your lordship's example, it would be the respondent who would be making that request.
Could be either party.
My lord, and that's what I'm saying, my lord, the respondent.
34 does not speak of only the successful party or the unsuccessful
But then
party.
your
It
lordship-
just says a party.
Yes.
So why should we limit it to one or the other?
My lord, my understanding, my lord, of 34(4).
A party may have succeeded partly in award, but it may be aggrieved by the part to the extent partly gone against him. A party normally will be filing an application in the 34(1) only if they agree by the award,
Yes.
not if they're satisfied and happy with the award.
And there, my lord, ordinarily the other party would be seeking to support the award.
Correct.
But
But the other
those-
party may, look, please. As far as procedural review is concerned, we don't require any provision in the act.
Hmm.
That's a power which is now well established, is available across to all courts and tribunals without any specific power of review. For substantive review, there must be a power. This goes beyond substantive review. This
Yes.
certainly goes beyond substantive review.
Yes. Look,
What is being put to you is, suppose there are 5 claims awarded.
yes.
4 claims are all right. One claim, the party says, one party says is already settled. That document has been suppressed or not produced. Matter goes back. Cannot the arbitrator sever that claim and retain the award for 4 so that the grounds for setting aside is awarded for the court?
But then your lordships are giving a power of substantive review to the tribunal in that case.
Yes, there is.
Because that document was
There
presumably
is.
there before.
Let me put it. Suppose a particular article of the Limitation Act has been applied.
Has been, my lord?
A particular article of the
Yes.
Limitation Act has been applied
Yes.
by the arbitrator. And the court finds that article is not applicable.
Yes.
So the court may record, let it be go back, let him examine because the arbitrator may have decided that issue and not decided because he held it to be barred by limitation, not gone into the other aspect.
Yes. Well, my respect
They
to
record
submission,
that.
that would,
This is a position, please now examine
yes.
in light of these judgments, which are clearly against. Like there's a difference between a loan and deposit. You apply the provision of a loan and not the deposit, the answer will be, limitation periods will be absolutely different.
My lord, your lordships are right, my lord, and there are examples. My only submissions would be twofold, my lord. Your lordship, in fact, asked this question last week, that what determination does the court have to make before it, my lord, sends the matter back to an arbitral tribunal? This will raise, my lord, one issue that in effect, the court is almost finally deciding a 34, but then just stopping short and saying, my lord, go back to the arbitral tribunal.
Correct? That's when they'll refer it.
But my lord, then it would open almost one more round in arbitration law.
But
Where you
much better
effectively argue
than
the
having
entirety.
de novo arbitration.
Yes. And the second aspect would be you are still conferring on the tribunal. You are still conferring on the tribunal, my lord, a power of substantive review. Where the tribunal has misapplied, as your lordship gave the example, a limitation act, or my lord, not considered a document that was before it in the proper context. That would, my lord, effectively be seeking that the arbitral tribunal review its own decision. Which decision then, my lord, again, is amenable only to the narrow challenge of 34. And that is why, my lord, in my respectful submission, there may be some cases where a re-arbitration is inevitable because you cannot confer the power of substantive review on an arbitral tribunal. Otherwise, my lord, 34(4) would then become, my lord, a longer process where you would first, as I said, my lord, almost decide the 34 and then send guidance back to the arbitral tribunal as to how to proceed. My lord, answer, my lord, then I come now directly to the guardrails that I propose, my lord. And it is very similar to what Mr. Kambata said in terms of the inevitable outcome. What I am trying to say, my lord, in my submissions is that keeping in mind these two objectives, both finality of arbitral award, but also a determination by parties that they will have an arbitrator decide their dispute. The way these two are reconciled, my lord, is if in a setting aside application, and acting only within the narrow confines of a setting aside application, therefore not reviewing the merits of the matter, the conclusion axiomatically follows as to what will happen in the remanded arbitration. Then to that limited extent, the court can modify the award. So, my lord, for example, in interest, if the arbitral tribunal has awarded interest contrary to the terms of the contract, and that is the reason the award on interest is being set aside, then the court can modify the interest rate. Because in a remanded arbitration or in a fresh arbitration, the only conclusion that will follow is the interest rate as per the contract. So, my lord, the way I try to articulate that in paragraphs 9 and 10 of my submissions, my lord, if your lordship will have it. Modification under section 34 is permissible only in situations where the court does not supplant the role of the arbitrator. Thus, for example, the exercise of modification cannot entail a review of the merits of the dispute. The court must find grounds to set aside the award or part thereof, and if the conclusion axiomatically flows from its findings, the court may modify the award to reach that axiomatic outcome. In that sense, the modification of the award is only a species of setting aside. And I've tried to give my lord two illustrations. Illustratively, if the tribunal awards interest contrary to the express terms of the contract, rather than relegating the parties to another arbitration, the court can grant interest according to the terms of the contract. Or B, if the tribunal finds breach of contract, but awards damages even though the contract stipulates liquidated damages, the court may modify the award and award liquidated damages in accordance with the contract. This then preserves for the parties that the decision is not being taken by a court when they have actually an arbitration agreement in place, saying that the arbitrators will finally decide the dispute between the parties. One last judgment, if I may place. This is a Delhi High Court judgment, which puts the submission quite succinctly. It is in my compilation. Page 320, my lord.
Award liquidated damages substitute is also not easy. They have to deal with extension letters.
No, my lord, if
That extent is virtually rewriting the award.
no, my lord, if the facts of delay are clear, only to that extent, my lord. If the quantum of delay
Pretty clear.
is already clear from the arbitral award and the court is not interfering with that, then you are doing a simple mathematics of 0.5% per week for X number of weeks. Or my lord, may I just take, not my example, my lord, a given example as my lord, the Chief Justice put it. If, my lord, the contract specifies a rate for the work to be done, and also specifies that if the work quantity exceeds a certain amount, a higher rate will be given. May I just end with this one illustration and then I'll place the Delhi High Court decision.
Please, just continue.
Yes. If the contract prescribes not a particular rate for the first quantity of work and then a higher rate for the additional quantity, the tribunal awards the higher rate for the entire quantity. And the matter is not challenged, saying that the higher rate can only apply to the additional quantity. If the court is setting aside the award for taking what is not a plausible view of the contract, then the court can certainly, in my respectful submission, modify the award to give that additional rate only for the additional work, rather than set aside the award, rendering the parties back to an arbitration where the outcome is already known. That's one of the facts of my case. Who's placing, my lord? This one?
Yes, please.
Yes, at paragraph 21, my lord,
Page
at
number?
page 325.
What's the name of the case?
My lord, this is Modern Laminators, footnote 8 of my submissions, my lord. 2008 SEC Online, Delhi, 956. These guardrails have been well put, my lord, and that's why I'm placing this judgment.
Modern?
2000.
Oh, you tell me.
Page 320, my lord, of my
320?
compilation.
Yes.
Union of India versus Modern Laminators. Right.
Filed by Miss Manisha Ambani.
No, my lord, by Mr. Nayak. I think my friend, my court master has pulled it out. No, the 10th.
Additional compilation.
Well, it's my compilation, additional compilation. Yes. Yes, my lord. Page 320.
Combined compilation of all the.
My lord, I
Should,
therefore,
in fact, sit down together at least 4
no,
5 days.
that's why I didn't duplicate compilations, my lord. What had already been filed by Mr. Datar.
All of you have spent so much money also just.
We tried in this compilation not to duplicate what was already filed.
Okay, yes, please.
Yes, my lord.
You have got a spare copy?
320, my lord, at 325. I'll just place these two paragraphs, my lord. Paragraph 21, my lord, at the bottom of page 325.
Yes, all right.
My lord had. No, no, Abbas. Nathan, may I place it while you're lordship?
Yes.
In my opinion, the power given to the court to set aside the award.
Paragraph?
Paragraph 21 at the bottom of page 325. Does my lord have it? In my opinion, the power given to the court to set aside the award necessarily includes a power to modify the award, notwithstanding absence of express power to modify the award as under the 1940 Act. Just as ONGC versus Saw Pipes interpreted the ground of award being against the public policy to include contrary to substantive provisions of law or against the terms of the contract. SVP interpreted the powers under 11(6) to be inclusive of judicial powers. The speedy disposal of lists is the underlying thought in the radical changes made in the arbitration law. If the powers of the court under Section 34 are restricted to not include power to modify, even where the court, without any elaborate inquiry and on the material already before the arbitrator, finds that the list should be finally settled with such modification, and if the courts are compelled to only set aside the award and to relegate the parties to second round of arbitration or to pursue other civil remedies, we would not be serving the purpose of expeditious or speedy disposal of lists and would be making arbitration as a form of alternate dispute resolution more cumbersome than the traditional judicial process. With great respect, I find myself unable to hold so. The Constitution Bench of Apex Court and SPP reversed the judgment of earlier Constitution Bench, inter alia holding that when a statute confers a power or imposes a duty on judicial authority, that authority, unless shown otherwise, has to act judicially. The Constitution Bench adopted the procedure laid therein in the context of the Act and to best serve the purpose sought to be achieved by the Act of expediting the process of arbitration without too many approaches to the court at various stages. And then, Milord, the guardrail also, para 22. Such modification of award would, however, have to be within the confines of interference with arbitral awards as held under the 1940 Act and would not permit the courts to substitute their opinion for that of the arbitrator. Such modification of award will be a species of setting aside only and would be setting aside to a limited extent. However, if the courts were to find that they cannot, within the confines of interference permissible or on the material before the arbitrator, are unable to modify, and if the same would include further fact-finding or adjudication of intricate questions of law, the parties ought to be left to the forum of their choice, that is to be relegated under 34(4) of the Act to further arbitration or other civil remedies. So, my respectful submission is that within the confines of the jurisdiction of Section 34, if the courts are able to find that there will only be one conclusion of this arbitration, even if the matter was to be fully set aside and a new arbitration would to ensue, that axiomatic conclusion, the courts can substitute. Miller, just my final paragraph, because the expert committee headed by Mr. Vishwanathan Millard, Vishwanathan Committee Report Millard. My Lord, the Chief Justice has para 12 of my submission.
Yes.
For this reason, it is respectfully submitted that the guardrail identified in the T.K. Vishwanathan Committee report that a court may modify the award only in exceptional circumstances to meet the ends of justice may not be precise or narrow enough to be workable. Similarly, instances where interest rates have been modified on the basis that the interest rate does not reflect the prevailing economic conditions or where it is not found reasonable or in the interest of justice may also be too broad a power to confer to a court under Section 34 of the Act without limiting the power of this court under Article 142. This is, my Lord, paragraph 11 of Vedanta that was placed in the morning. My submission is, my Lord, that within the 34 jurisdiction, within that exercise, and only if an outcome inevitably follows, then the court may modify that award. And my lord, your lordship has been concerned, my lord, with interest rates being awarded by tribunals, either too much in excess or not being given. My lord, too much in excess, perhaps your lordship's decision in Nepal Limited versus Manoj Agarwal, where now a party that deposits the money in court while challenging the award doesn't continue to suffer the
No,
interest
no.
rate awarded.
So that's your wrong reading of it. That's your wrong reading of it.
Your lordships have said, my lord, that
No, no, in Nepal, the money was paid back, paid to the party
yes,
concerned.
taken out from the court by the party.
That therefore I said the interest will stop running.
I'm grateful, my lord. And your lordships are routine, my lord, the
No, no,
courts are
it's not-
routinely.
If you pay a deposit, the interest rate doesn't stop.
Correct,
Let-
you are
let's-
disputing the liability. That's settled, Ramanathan Chettiar.
No,
In
what I
Chettiar.
said, where the money has been paid to the party,
Yes, that's
withdrawn by the party, then it makes no difference, but where deposit of the money, you don't,
No, yes, I'm grateful, my lord.
you don't save yourself from the
Yes,
interest.
your lordships have said where it's deposited and withdrawn.
Maybe withdrawn also on furnishing security. In
Yes.
that case, it was made, it was not a bank guarantee and so forth.
Yes,
In bank guarantee cases, then we are asking them to pay even the bank guarantee.
a bank guarantee or some other security. That was my submission, my lord, that today, my lord, if a party is aggrieved by an award and the interest rate is very,
What was being asked for was, the money was taken away and utilized whatnot. Now the award was upheld, so he said, no, now you pay me interest on that amount, even including the amount which I drawn.
I was only trying to say, my lord, therefore, this issue of a very high interest rate has been largely addressed by your lordship's decision, because when you suffer an award and you are challenging the award and the interest rate, you at least deposit the money in court, it is withdrawn by the other party on furnishing a security.
So the times the government it suffers on this account because they say don't allow withdrawal.
No,
They
then,
deposit the money, but
my lord,
don't allow.
in that sense, my lord, and your lordships, my lord, have to deal with, my lord, a variety of arbitrations, my lord. But in a commercial arbitration, if a party refuses to comply with the award, then perhaps years later, it can only suffer the consequence of that high interest. I hope I mean, and that's why, my lord, NEPA offers that opportunity to a party to say that if the award of interest is too high, you can stop the clock by depositing the money, and with an order of a court, the other side is permitted to withdraw the money. But if you don't deposit the money or resist a withdrawal of the money by the other side, then perhaps you don't need the discretionary relief of a court to later say the award of interest is too high. I'm very grateful, my lord. Therefore, I would only end with this.
Yes, please.
My lord, I would only end with this one last line. The Lakshman Rekha, according to me, is, my lord, that courts will not substitute the decision making of an arbitrator. Within that confine, and acting within Section 34, if there is a certain conclusion to the dispute, the courts are, my lord, empowered under Section 34 to make that modification. I'm deeply obliged.
Sir, I am principally concerned with statutory arbitration.
You are appearing in which case?
In high number 100523
Okay.
and other
Statutory
connect
arbitration arising out of?
National Highways Act.
For the private party or the?
Private party whose land is acquired. So my first submission is that there is a fundamental difference between statutory arbitration under the National Highways Act and arbitration under the Arbitration Act. Arbitration under the National Highways Act involves public law elements. How to determine the compensation for the land which is acquired? All principles fall in the domain of public law. While commercial arbitration involves private law elements. This is one fundamental difference between the two. The second difference is that commercial arbitration is consensual. It's with the consent of the parties. While statutory arbitration is involuntary. I do not choose the arbitrator. under section 3G, the arbitrator is appointed by the central government under the provisions of the National Highways Act. This court has noted in Hakim's case that there is inherent bias. Kindly see me lot para 50, 55 and 59 of Hakim's case. It is there in Mr. Datta's compilation.
Para?
Para 50, 55 and 59. And apart from this para, your lordships can take judicial notice of the fact that several cases have come to this court where the amount which is awarded under such arbitration is very small.
Very big.
That is why your lordships have interfered under Article 142. Even in this case, Hakim's case, your lordships have interfered, exercised power under 142, and your lordships have declined to interfere with the impugned award. Kindly see para 50. There is no doubt that, as argued by Mr. Balasubramaniam, the arbitral award in these cases is given by a government servant appointed by the central government, the result being the rubber stamping of compensation awarded or a completely perverse basis, given the facts that in these petitions at least the constitutional validity of energy laws has not been challenged. We must proceed on the basis that a grave injustice would be done if we were to interfere on facts, set aside the award, and remand the matter to very government servant who took into account depressed land values which were relevant for the purposes of the stamp duty only. It may be mentioned at this juncture that a limited challenge was made to section 3J of the National Highways Act. Now this has been struck down. Then kindly come, my lord, to para 55.
Validity is pending, I think now, on 3G is pending. 3G is pending.
3J is struck
struck
down now.
3G
So therefore,
3G is pending.
no, 3G, this arbitration was under 3G.
It's pending, validity is pending.
So 3J is struck down. Therefore, all the principles which apply to acquisition under the Land Acquisition Act apply with equal force to this acquisition also. Now kindly see, my lord, para 52, page 31 of the report. As has been stated by us, the object of the NH laws is to expedite the process of acquisition. This has been achieved by cutting down the period for hearing the objections from 30 days under Section 5 of the Land Acquisition Act to 21 days under Section 3C of the National Highways Act. Further, unlike the Land Acquisition Act, moment the notification under Section 322 of the National Highways Act, equivalent to Section 6 of the Land Act, is made, the land vests absolutely in the central government, free from all encumbrances. Therefore, where the land has vested in the central government and the amount determined by the competent authority under Section 3Z as compensation has been deposited by the central government in accordance with Section 3H1, the competent authority may also direct that possession be taken within so and so. Then kindly come to para 55. It can be seen from the aforesaid provision that the speeding up of acquisition of land needed for national highways has been achieved. The challenge process to an award passed will of necessity take its own time, both under Section 3G of this Act as well as under the provisions of the Land Acquisition Act. This being the case, it is a little difficult to appreciate as to why the wholesome regime of appeals under the Land Acquisition Act has been replaced by a regime in which an award passed by the arbitrator, who is not consensually appointed but appointed by the central government, can only be challenged not on merits but on the limited grounds contained in Section 34. Now, this is precisely what my contention is. Now, therefore, your lordship will see that if there is a fundamental difference on two counts, one, the applicability of the substantive law, and second, the absence of consent, these two elements would have their own impact on the power of the court under 34. Now, as far as statutory arbitration is concerned, therefore, there is a fundamental difference between statutory arbitration and commercial arbitration. Now, in this light, kindly come, my lord, to one more aspect. Hakim notes the judgment of the Constitution Bench in Nagpur Improvement Trust. Kindly turn to para 58 on page 33.
Yes.
It is now well settled that the state can make reasonable classification for the purpose of legislation. It is equally settled that the classification, in order to be reasonable, must satisfy two tests. Differentia must have a rational relation with the object sought to be achieved by the legislation in question. In this connection, it must be borne in mind that the object itself should be lawful. The object itself cannot be against the sections of my discriminatory for otherwise. For instance, if the object is to discriminate against one section of the minorities, discrimination cannot be justified on the ground there are reasonable classifications because it has a rational relation to the object sought to be achieved. What can be reasonable classification for the purpose of determination of compensation if the object of the legislation is to compulsorily acquire the land for a public purpose? It would not be disputed that the different principles of compensation cannot be formulated for lands acquired on the basis of the owner is old or young, healthy or ill, tall or short, or whether the owner has inheritable property or built it up with his own effort, or whether the owner is politician or an advocate. Why is this sort of classification not sustainable? Because the object being to compulsorily acquire for a public purpose, the object is equally achieved whether the land belongs to one type of the owner or another. Can classification be made on the basis of a public purpose for the purpose of compensation for which land is acquired? In other words, can the legislature lay down different principles of compensation for lands acquired, say, for hospital or a school or a government building? Can the legislature say that for a hospital, land will be acquired at 50% of the market value, for a school at 60% of the value, and for government building 70% of the market value? All three objects are public purposes. And as far as the owner is concerned, it does not matter to him whether it is one public purpose or the other. Article 14 confers an individual a right in order to justify classification. There should be something which justifies a different treatment to this individual right. It seems to us that ordinarily classification based on public purpose is not permissible under Article 14 of the for the purpose of determining compensation. The position is different, etc., etc. Now, therefore, the principle that emerges is that whether you acquire under the Land Acquisition Act or whether you acquire under the National Highways Act, I must get the same level of compensation. Now, if this is the principle, will it or will it not have an impact on the content and the amplitude of power under 34?
The difficulty is the challenge is on the restricted ground of 34. It makes no difference.
I'll come to 34.
But if we accept that the grounds of challenge can be increased or decreased depending upon this, whether departmental officer is the arbitrator, as it used to happen before the constitutional bench says independent arbitrators have to be appointed, it will lead to a problem. But we can't expand and decrease the scope of.
So the principle as far as substantive law is concerned is same.
Put it may be a indirect influence, not a direct influence, as far as 34 is concerned.
So Article 14 has other dimension. Now, this is as far as substantive law is concerned. Now, as far as the forum is concerned, in my respectful submission, Article 14 will have its impact on the content and the amplitude of the power under 34.
What precisely is your argument?
My argument is this, that in case of commercial arbitration, the private law elements are involved. While acquisition of land for a public purpose under the National Highways Act or under any other compulsory law of acquisition, the parameters are different. And if that is so, and if the arbitration is involuntary, the jurisdiction of the court under 34 must be differently viewed. You cannot have, if you have the same standard in all cases, whether commercial arbitration, consensual arbitration, compulsory arbitration, public purpose, etc., then two dissimilar situations, jurisdiction will be same, and that would be violation of 14.
Bilateral arbitration, particularly after court, these provisions have become suspect, subject to what the
So
union.
the remedy also must be of the same level.
How can 34 scope be different, Mr. Nabde?
The 34 scope will be different for the simple reason that the parameters
He's violated the statutory provision. And that is the cause for the patent illegality of fundamental. Then in that case, we can expand, we can stretch that legality. But the power of modification has to be read into 34. Or under 34(4) as
I have
a.
still not touched 34. I'll come to 34 a bit later. But
We have understood this
my
argument.
proposition
We have-
is this.
we have
Now
understood
take a
this.
case, for example, your lordships have said if the acquisition is under the same notification, then the rate of compensation to two different owners must be same. Otherwise, there is infraction of Article 14. Now suppose in a case arising under the National Highways Act, two different owners are given two different rates of compensation and their properties are acquired under the same notification. Then a restricted view of 34 would warrant that the discriminated owner has to go back and start the process all over again. Now look at the kind of injustice. It will defeat the very objective of expeditious resolution of disputes. I am not saying that in every case the court will have power to modify. But to take an extreme proposition that in no case the court can modify would be too wide a proposition. Too wide a proposition. Now, sir, come to section 34. Let me make my submission on 34. First, this power is conferred on a civil court. If your lordships may have a look at the definition, it says a principal civil court of original jurisdiction which could have taken cognizance of the subject matter of the arbitral dispute. Now, why this power is conferred on a court and not on a person or designator? There is a reason for it. And we proceed on an assumption that when Parliament enacts a law, the Parliament is aware of the existing law. Now, what is the existing law as far as the civil court is concerned? Two propositions. It can take cognizance of matters of a civil nature unless its cognizance is expressly or impliedly barred. That is proposition number one. Proposition number two, that it has inherent power to do justice. Now, in order to curtail these powers, that is, power to take cognizance of matters of a civil nature and power to pass such orders as are necessary to meet the ends of justice, you need specific legislative provision. In the absence of any prohibition or any absence of any restriction on the exercise of this power, the court is free to pass any order that is required to meet the ends of justice. Now let me show to your lordship in this context what fetters have been placed on the powers of the court. So first, kindly come, my lord, to section 5. Section 5 of the Arbitration Act. Notwithstanding anything contained in any other law for the time being in force, in matters governed by this part, no judicial authority shall intervene except where so provided in this part. In the absence of this, a civil court was competent to take cognizance of a matter of a civil nature. Under the 1940 law, merely because there is an arbitration clause, the court's power to adjudicate upon such a suit was not taken away. In fact, under that law, the court was required to pass an order staying the suit and allow the arbitration to continue. But if that was not done, any arbitration that would continue without the court stay would result in a nullity. So, Section 5, therefore, alters the existing law. It's a fetter which is placed on the court's power. And why those provisions in the 1940 Act? The reason was that the court was competent to take cognizance of the matter, but if there is an arbitration clause, the court is empowered to stay the suit. In other words, the court puts a fetter on its own jurisdiction. Now, this is completely altered by Section 5. And the proposition is that any provision which restricts the power of the civil court must be strictly construed. So if two views are possible, then the one in favor of the jurisdiction of the court must be preferred. And this is precisely the present situation. Then kindly, sir, Section 8. A judicial authority before which an action is brought in a matter which is the subject matter of an arbitration agreement shall, if a party to the arbitration agreement or any person claiming through or under him so applies, not later than the date of submitting the first statement on the substance of the dispute, then notwithstanding any judgment, decree or order of Supreme Court or any court, refer the parties to arbitration unless it finds that prima facie no valid arbitration agreement exists. Now, this fetter is couched with rider. It says that if the court prima facie forms a view, then only this power can be exercised. So therefore,
On an application, Mr. Nabde.
on the application,
Suppose somebody doesn't apply at all.
then the suit will proceed. That's what I'm saying. That therefore your lordship will have to see the provisions of the act in that perspective, that whether there is a fetter and whether the court's jurisdiction is completely taken away to pass orders on even on merit, then your lordship will come to section 9(1). A party may before or during arbitral proceedings or at any time after making of the arbitral award, but before it enforced in accordance with section applied to the court. So again here some fetter is put on the court's power under 9(1). Then kindly see 9(3). Once the arbitral tribunal has been constituted, the court shall not entertain an application under subsection 1 unless the court finds that the circumstances exist which may not render the remedy provided under section 17 efficacious. So here again a power has been restricted, but in certain circumstances the court can still exercise power under section 9. Then your lordship will come to section 11(6)(a). The Supreme Court, or as the case may be the High Court, while considering any application under subsection 4 or subsection 5 or subsection 6, shall notwithstanding any judgment, decree or order of any court, confine to the examination of the existence of an arbitration agreement. So the jurisdiction is restricted. Then your lordship will come to 37(3). Kindly see 37(3). No second appeal shall lie from an order passed in an appeal under section, but nothing in this section shall affect or take away any right to appeal to the Supreme Court. Then your lordship will come to 42. Notwithstanding anything contained elsewhere in this part or any other law for the time being course, where with respect to an arbitration agreement, any application under this part has been made in a court, that court alone shall have jurisdiction over the arbitral proceedings and all subsequent applications arising out of the agreement and the arbitral proceedings shall be made in the court, in that court and in no other court. So therefore, your lordship sees that whenever the legislature wanted to put fetters on the court's powers, it has done so. Now I come to the second proposition. Court has inherent powers. I take it that nobody is disputing that the power under section 34 is a judicial power. In any case, that issue has now been resolved in Patel engineering case, that even power under 11 is held to be judicial. Now, if it is a judicial power, where is it defined in crystal clear terms? If it is not defined in crystal clear terms, then a proposition follows that it's a power which is not limited by any limiting factor, which is to be found outside the provisions of the Act. So if any limiting factor is to be found on the court judicial power under 34, it must be found in the Act itself. If it cannot be found in the Act itself, then in my respectful submission, that power remains unlimited.
Only if 34(2).
I'm coming to 34(2). Now I draw distinctions between section 34(2) and section 34(2)(a) on the one hand and 34(1). Now 34(2) and 34(2)(a) deal with jurisdictional issues. They do not define the powers of the court under 34. They are jurisdictional issues, that when can a court take cognizance of a matter under 34 when the circumstances enumerated in section 34(2) and section 34(2)(a) are shown to be existing. The power flows out of 34(1). That's my submission. Now kindly see 34(1). Recourse to a court against an arbitral award. Now my emphasis is on the word recourse to a court against an arbitral award. Now that recourse is for what? What is the concept of recourse to a court? This concept necessarily postulates a power, a right to seek justice. No other interpretation is possible. It's a recourse to seek justice. And therefore, if it is a judicial remedy, and if Section 34 does not define or does not limit the court's power, then in my respectful submission, the court has power to touch even the merits of the case. So the second aspect now. Now, let us take a case where the award is set aside, but the list still survives. Now take for example, the arbitrator wrongly rejects the claim, contrary to all settled principles, or does not allow substantial evidence to take part of the record. Complete denial of natural justice. Award is required to be set aside. That does not put an end to the list. If the list survives, then there are four possibilities. The court says nothing. Because if we go by the rule of strict interpretation, after setting aside the award, the statute does not make us wise as to what is to be done.
No, 43 does provide for that. 43 does provide for that. Section 43 does provide for it.
So
Says
I'll
both
come to
options.
that.
We have two options, either to go
That
to
I
the
will
court.
come to 30. I'll come to that provision, subsection 4 of section 43 a little later. But 34 does not. 34 does not itself say. There cannot be vacuum. The list remains, there can't be vacuum. Now kindly have a look at, in this context, 43(4).
Yes.
Too literal an interpretation of 43(4) will play an havoc. Where the court orders that an arbitral award be set aside, the period between the commencement of the arbitration and the date of the order of the court shall be excluded in computing the time prescribed by the Limitation Act for commencement of proceedings. Mark that word, proceedings, including arbitration with respect to the dispute so submitted. Now, this provision contemplates two things: arbitration proceedings and some proceeding dehours arbitration. Will it be a suit? What is the nature of that proceeding, which is other than arbitration proceeding? My respectful submission is that 34 does not tell us. I'm not on the content and the amplitude of the power. I'm on whether it is original. The court jurisdiction under 34, is it original? Is it appellate? Or is it revisional? Whichever way that your lordships are inclined to take a view, the court still has the power to pass appropriate orders. Otherwise, there would be a vacuum. The court simply sets aside the award and leave the parties to decide for themselves what is to be done. This creates a situation of uncertainty.
Why, Mr. Navade? Suppose it is set aside on the ground that it contemplates matters beyond the scope of arbitration.
Then matter ain't no. Therefore, I said where the list survives.
List survives and that will be suit.
because it's not arbitrable and period is excluded.
If it is not arbitrable, then the party concerned would take appropriate either a suit. Take for example testamentary matter, not arbitrable. Then the party concerned will go and file a suit or testamentary petition or whatever is the remedy. But the point is that the list survives. It may survive not for the purpose of arbitration, but it does survive.
Now, there are two things. Why they say list survives. Sometimes when you decide the matter in the section 34, the list may not survive. Suppose it says, comes to the conclusion that the first arbitration, that the termination of the contract is valid, and that is upheld by the court.
So that's what I
That's
said.
been upheld
If
by the court.
therefore,
But where the court interfered was with regard to, say, a small aspect with regard to the enhancement of prices of the goods or the services. That the court says in terms of the arbitration clause, that could not have been awarded. The list doesn't survive. Where the list survives, you'll be entitled to exemption. This was there in the fourth schedule of the 1940 Act.
but the question is, if the dispute is arbitrable, so I am concerned with the question where the dispute survives, the list survives, and dispute is arbitrable within the four corners of the arbitration clause. Then what the court is supposed to do? Because 34 does not tell us, 43(4) also does not tell us what consequential orders the court should pass.
You'll have to either go in for 11(6)
So
for
therefore-
appointment of a fresh arbitrator or file a civil suit. In that, you say by list survives.
So the Act does not tell us that in such a situation,
Why will the Act tell you? Why will the Act tell you? Will not guide you, hold your hand and tell you. It's so that that's why we have lawyers.
I can suggest a better answer with respect, my lord.
Yes, please do.
Now take for example 32. The arbitration comes to an end once final award is passed. Unless for other reasons that time is over, etc. Now once the award is set aside, there is no award in operation. Therefore, one can possibly take a view that the arbitration automatically revives.
That's not provided in the Act.
That's what I'm saying. The
No,
Act-
it is not provided. Automatic revival is not provided.
Their Act does not say so. Act does not say so. The point is, now take for
In fact,
example,
in one of the
take-
cases, with Sanjiv Kumar, it was a case in which, there was a claim made against the insurance company. Insurance companies, the arbitration clause does not permit you to arbitrate on the question whether the claim is payable. Only on the question of quantum of claim, arbitration is possible, as per the decisions of this court.
sir, take a case.
So there, the third bank came in and moved an application to Section 8, which was allowed. And the matter was referred to arbitration. Award was pronounced, it was struck down that the arbitration clause is limited. We passed an order reviving of the suit, because there, it could have been possible because the suit was already pending.
Suppose the arbitration revives. It will be again the same round, challenge under
Yeah, but
34, and this can continue ad infinitum, then the cost involved in
That-
arbitration.
That is
time
always so in remand.
Therefore, now 34 does not even contemplate even remotely of remand. Now one example I'll give you. Section 37 did not prescribe limitation. Your lordship read into it. Your lordships read into it because of,
Now we've removed it, we've made it applicable as per.
question is therefore, your lordships are reading, not take for example, an arbitrator
I couldn't
being
understand.
appointed only
We have-
by one party.
Mr. Lafter, we have understood this argument. Anything else now on this?
So therefore, there is a void. Now, Mr. Datar argued that then supply some words. I am dealing on that part of the, I perhaps do not agree with him on that part of the matter. Your lordships have consistently taken a view that a case of casus omissus is to be rarely and rarely invented And in the absence of a clear-cut measure, your lordship have to see the scheme of the act, the object to be achieved, what remedies, judicial remedies are provided for. Now, in my respectful submission, in this case, we don't have to go in search of casus omissus. We don't have to supply words. The answer is to be found in section 34 itself. And that answer is this. Take a case, for example, where there is enough evidence on the record of the arbitrator, but he does not follow. I'm not saying wrong application, because now wrong application also door is sought to be closed by the proviso to 34(2)(a). I'm conscious of that.
So you are in favor of court taking.
But suppose it does not follow. Now take a case of solatium. Take a case of solatium. The arbitrator does not grant solatium. What is to be done? The court is powerless. Now that would render that remedy under 34 an illusion. An illusion. The remedy has to be effective. And that has to be effective within certain definite time span. Least expensive. If these are the twin objectives of the arbitration law, then asking him to go back and then take it years, and by that time the real value of the money, what I get today, 100 rupees, after 20 years, it will not be even worth 1 rupee. This is the situation. Therefore, in my respectful submission, two propositions. One, that we are dealing with dissimilar situations, public law element in statutory arbitration, involuntary arbitration, as against that commercial arbitration based on contractual obligation. Therefore, we cannot have a same standard to measure the width and the amplitude of the court's power under 34. Otherwise, it will lead to infraction of Article 14.
Okay, thank you. Yes, please.
One minute. Sir, before I close, I don't want to show to your lordship, but there are several statutes which deal with statutory arbitration.
Correct.
Atomic Energy Act, Chit Funds Act, and all wherever this statutory arbitration is provided for, there are different parameters. In some cases, appeals are provided for.
Correct.
In some cases, a different kind of procedure is prescribed. Now, therefore, we cannot have one standard measure to assess the width and the amplitude of court's power under 34. It will be in my respectful submission.
Nowadays, you may be better off. Since power is not traceable, you may file a writ petition and show discrimination and get relief.
No, but
Whereas the private party may not.
all principles of administrative law must apply. And
No.
then who can apply?
So if power is not located in the act, then it's not barred. You may file a writ.
No, but then if I come under 226, the first thing High Court tells me there is a remedy under 34.
No, but 34 doesn't provide
then-
for what I'm asking.
Then your lordship will have to hold that this is an illusory remedy, not effective.
According to what they say, and if we accept 34 doesn't provide for it,
No,
then
therefore,
it's a remedy only to be ventilated before the writ court.
therefore I am trying to avoid a situation that remedy becomes an illusion. May I hand over the list of only those statutes?
That's fine.
List of
Yes,
those
please.
statutes. Because
One
your
by one
lordship
now.
have to consider this.
5 minutes now. 5 minutes and we will.
Will not apply of the act.
Yeah. And sir, one more.
One by one, if you give in your slips, they call you by name.
And the second is the list of provisions of the Arbitration Act which can never apply to involuntary arbitration. Take.
Okay. All the names.
Mr. Sumit Pushkarna.
I am grateful. It is not. Violation we are handing over. Appearing for a PSU, TCIL, and not the primary line of argument that we are having is for modification. If your lordship will just have the compilation, Lord, we also have a ready compilation of chart. What we have done is, Lord, we have put a comparative of all sections, but I'll first, Lord, begin with the what is the theme of the Lord argument. Lord, the theme of the argument, we are not going presently on 34 because, Lord, almost everybody has argued on 34. Your lordship, Lord, when the question was referred to this bench, also covered section 37, Lord, which for its scope and powers. So, Lord, we are going to start with section 37 because, Lord, our argument is that if section 37 is examined closely, and our argument is twofold. First, that it is the first appeal. Unlike, my lord, the argument which is being raised, it appears to be a second appeal, which is actually a first appeal. Your lordship will see that from.
We are not examining that question. We'll leave it aside. Whether the power under 37 is equally wide as 34 or more restricted as some judgments have said, we are not going to go to that.
My lord, that will be necessary for a moment, my lord, for a simple reason. Your lord.
Only to the extent modification. If we hold.
Lord, I'll just clarify. Just for once your lordship, Lord, once your lordship sees it. Lord, the argument is simple. As far as Lord, today we have two, in fact, sides of judgments. One which says, my lord, that 37 is narrower than 34. That's the one line of argument. The second, my lord, which is the liberal one, says that 37 is at best equal to 34. There is no line which says that 37 is actually.
That can never be.
Lord, your lordship will bear with me for 5 minutes, then I will leave it to your lordship. Lord.
Are you propounding 37 is wider than 34?
Yeah, absolutely, my lord. We are saying 37 is like a regular appeal. If your lordship, my lord, sees.
If the first trial court cannot go into the question, the second.
No, that's the reason. If your lordship, my lord,
okay, please argue on that.
Yes, my lord. Answer to that lies in section 36. If your lordship sees 36, my lord, it will become clear. My lord, and the answer is after 36, because 36 uses two phrases. First is decree, that it award. It doesn't say, my lord, at the stage of the award that it is a decree. It says at 36, after the 34 scrutiny is over, that it becomes a decree of the court. And then it says in 36.3 that it is to be treated as a money decree. If your lordship will just have 36, my lord, for a moment. And Lord, I will also clarify why this power has been kept separate. And what are the kind, Lord, your lordship will also have to keep in mind that when we adopted the UN sectoral model, there are few provisions which are there only in our act and it is not there in the UN model. For instance, 34 capital 2A, which provides that two critical elements, that is the power to reappreciate the.
We are aware of that.
So, my lord, those two have been specifically kept in our act. They are not there in the UN.
That come by way of amendment.
Yes, my lord. My lord, your lordship will see 36 now.
Yes, please.
36, where the time for making an application to set aside the arbitral award under section 34 has expired, then subject to the provisions of subsection 2, such award shall be enforced in accordance with provisions of the Code of Civil Procedure in the same manner as if it were a decree of the court. Then your lordship will turn to the proviso of 3.
Yes, please.
Upon filing of an application under subsection 2 for stay of the operation of the arbitral award, the court may, subject to such conditions as it may deem fit, grant stay of operation of such award for reasons to be recorded in writing, provided that the court shall, while considering the application for grant of stay in the case of an arbitral award for payment of money, have due regard to the provisions for grant of stay of a money decree under the provisions of CPC 1908. That's Order 41, Rule 5. So, Lord, we have a position where 36.1 is talking about it being treated as a decree, and 36 Proviso 3, which says that it is to be treated akin to a money decree. Now, my lord, your lordship will turn to 19 for a moment.
Section
19. Section 19, my lord, which says determination of rules of procedure. Because, my lord, the argument is also that CPC is not only a procedural law,
to the extent an appeal is provided, it can also be considered as a substantive law. Your Lordship has dealt with that in a number of judgments. 19.1. The arbitral tribunal shall not be bound by the Code of Civil Procedure or the Indian Evidence Act. Now, Lord, the argument which has already been upheld in ITI, the judgment which by learned friend read in the morning, was that it is not bound, does not mean that CPC is excluded. It only says that the view can be more liberal. So other than the principles of CPC and Evidence Act, an arbitrator could probably go and have a more liberal view. And in fact, Lord, that is the reason I am saying that the scrutiny of 37 has to be more rigorous, because 34 provides only for a curtailed scrutiny, and it is like it's a position, I would say, to the extent of going, to the extent of saying that it merges into the award, and it is for the first time in 37 that the decree or the award merging with the 34 order is actually tested. That is the reason, my Lord, your Lordship will not find any other
We have
provision.
understood that argument. That we can be prophesied, it's not a case of reverse pyramid.
Lord, okay,
Yeah,
Lord, I'll leave that argument for the moment. Your Lordship will now
Come to any other argument.
Yes, my Lord. Your Lordship will see 19.4. 19.4 for a moment, my Lord. The power of the arbitral tribunal under subsection 3 includes the power to determine admissibility, relevance, materiality, and weight of any evidence. Now, my Lord, please envisage a position where there's an arbitrator who is not even a law graduate, because the International Act has provision where experts like architects or other construction experts can be arbitrators. Now he is going to determine things under 19.4 with respect to admissibility, relevance, materiality, and weight of any evidence. Now, please, in this background, my Lord, please come to 28 for a moment.
Yes.
28, rules applicable to the substance of the dispute. This is, Lord, where we are building the power for 37. Where the place of arbitration is situated in India, in an arbitration other than international commercial arbitration, the arbitral tribunal shall decide the dispute submitted to arbitration in accordance with the substantive law for the time being in force in India. So, Lord, CPC in that sense, when it provides for an appeal, here we have a section 37. Lord, I am not.
Mr. Pushkarna, do not press this point more.
Okay.
You're not going to carry it forward.
No, Lord, just one more power can I?
We have understood, but it's not going to help
Okay,
you
Lord,
further.
your Lordships
You're
can then refer
curtailing somebody else's time.
Okay, Lord. What 3 and 2, your Lordships, when your Lordships is reading, can 3,
We
20
go
and
through
3
your
and
written
2.
submissions that with regard to 37, but we not press that one.
Okay. Lord, then your Lordship will also, Lord, in that light, come now to 34, 2 capital A.
Yes.
Now, Lord, 2 capital A. And the reason I was reading that
so many times.
Lord, 2 capital A.
34 to A.
Yeah, 34, 2 capital A, Lord.
Yes, that has been read from yesterday, so many.
Yes, Lord, I want to probably read it.
So you make your submissions, there is no point in reading it again.
Lord, I will only read the proviso, Lord. Can I read the proviso?
Yes, please.
Yes, Lord. That an award shall not be set aside merely on the ground of an erroneous application of law or by reappreciation of evidence. So, Lord, this was the reason I was reading 28 and 19 to say that those are the aspects which 2A has been specifically brought in our statute.
Let us put it very clearly. The argument that 37 power is wider than 34 is unacceptable. Maximum you can argue is 37 being your first appeal. The power will be coterminous as wide as 34. Subject to, obviously, in case there is on the ground of perversity or fundamental laws of India, there is a finding. Probably if two courts, a tribunal and the trial court have examined that issue, one will say that one should not interfere even if one has a different view. That is something which we do when we hear appeals on bail against we do for when you hear appeals with regard to cancellation of bail or acquittal, etc. That's all.
Lord, I would only say that your Lordship says, I bow down to Lord, obviously what your Lordship is saying.
That
37, 3, Lord.
Please, I don't think this will carry water. Let me very.
Lord, then I would
You
only
are not
say
right.
this
You are not,
as-
Mr. Pushkarna, you are not right in assuming that moment a 34 is dismissed, it becomes a decree. Even on filing of a 34, unless there is a stay, it's an enforceable award after the 2015 clarification. The law, according to the court judgment, is always like that.
37 moment it is filed, if a party has a prima facie case, there would be again an interim or suitable interim order. So again, it won't, you are assuming that it is at that stage a decree and proceeding and forgetting the principle that an appellate power is coextensive with the original power. So please leave that argument as a Chief Justice.
Lord, I go down to that. Your Lordship in the morning, Lord, if your Lordship recollect, spoke about 151 CPC and the inherent powers. Now, Lord, when your Lordship was talking about 151 CPC, it was in that light, Lord, Order 47, Order 41, Rule 23 to 33, my Lord, would also become relevant for reading along with 37C. Because, Lord, what happens when the court receives an appeal under 37C?
Mr. Pushkarna, don't press this more.
I'll leave it
I
at
don't
that,
think
but
it's
I
going to
have
cut
make an
time.
argument that's the
And
point.
36(1) was, what you read was originally enacted, then 2016 amendment, it was broadened to make it more enforceable. So leave that, let's not go into all that. We cannot accept the argument that 37 power is greater and wider or broader than 34. Sorry.
That's the reason your
It's
Lordship.
too,
Okay.
that do not convey the point anymore.
I'll leave it there. I'm not for the benefit of this court. I have a chart, Lord, I'll just hand over.
Okay, that is that.
This has a summary
Yes,
of
please. Anybody else?
provisions, Lord, which we have
Get
discussed.
call out the name.
Yes, sir.
Grateful.
So just 5 minutes, I think. The night watchman, one of the most points covered, madam, and just 3 points I want to point out. Just give the written submission. One of the 3 points which I'd like to focus on, and very quickly, my lords, is that under section 34, my lords, there's the inherent powers of court and there's a discretionary power. There is a discretionary power which is there under 34, and that gives its own power to modify. That's where the power of modification arises from. That is number 1. Second, from that discretionary power also arises the power to sever parts of the award and set it aside. That's where it arises from. And if, my lords, there is no issue between the other side and us that severability is acceptable, then severability is also a kind of modification. That I will just show one judgment on that. Now, if severability is a kind of modification, my lords, there is no bar on other forms of modification by the award. That's the second point I want to highlight. And the third part which I want to highlight is the nature of modifications. My learned friend has already read modern laminators, just 1 or 2 points there I'll put. So, my lord, just starting first, may kindly come to 1.1 of my submissions. That talks about 34 of the Arbitration Act. The Act gives a discretion to the court not to exercise the ultimate power of setting aside in every case. This is clear from the use of the word may. And in that case, in that context, my lords, I have cited R.S. Jivani case, that is PDF 258 of the judgment, common compilation of judgments, PDF 258 at PDF 286, where para 16 it is stated, may indicates that larger discretion is vested in the court, which has to be exercised in accordance with the settled canons of judicial discretion. And the context would require that the expression may should be read as may alone and does not invite any other meaning or interpretation. So, my lords, with the inherent powers of the court, with this concept of discretionary power, which is there, my lords, to be exercised for judicial, as per well-settled judicial canons, my lords, I would suggest that this is the origin of the power which would come to modify the award. Then, my lords, may kindly come to cases where, my lords, and 1.3, that where parts of the award have been set aside on the ground that it is, my lords, the logic which is put forward, which is that each part of an award is like an interim award. The severability is distinguished from modification in the Delhi High Court judgment by Justice Verma by saying that each claim is like an interim award. If you set aside that interim award, that part of the arbitration goes is actually a power of setting aside which is being exercised. My lord, with respect, my lord, the argument which I would comment is this. The Act distinguishes between an interim award and a final award. It provides procedures under which a final award is to be passed. Once a final, unlike an interim award, which is passed and it can be challenged also, the arbitral proceedings cease on a final award being given. Once the arbitral proceedings cease and it becomes a functus officio, my lords, it's treated as a final award. Now to read in a fiction into that, contrary to the Act, that actually, no, it's not a final award, it actually is a conglomeration of different sets of award, is stretching the language too far. I would rather comment the argument that, my lords, actually this severance is a form of modification. It's one type of modification. And under section 34, that is not the only type of modification which can be exercised. There can be other types of modification of award within certain guardrails, which I will point out. So, my lords, I come to straight away at page 3 of my written submission, 2.1, where I've defined modification as a change to something, an alteration or amendment. And then, my lords, Puran Lal Lakhanpal, I have quoted, my lords, I'll pass on the judgment. I won't take time to read it out, but just the relevant para. The word modify means inter alia to make partial changes in, to change as object in respect of some of its qualities, to alter or vary without radical transformation. Similarly, the word modification means the action of making changes in an object without altering its essential nature or character. The state of being thus changed, partial alteration. Stress is being placed on the meaning to alter or vary without radical transformation on behalf of the petitioner. But that is not the only meaning of the words modify or modification. The word modify also means to make partial changes in, and modification means partial alteration. So, my lords, that is the scope and ambit of modification, which has to be given full play to from the discretion of the court under 34(1). Then, my lords, I may just come down to the final point which I want to make. I won't take much time. And that is the nature of modifications, other kinds of modifications can be carried out. It would be dangerous to limit it to certain types of modification. The inherent powers of the court are there, case by case, depending on a case, the court may exercise. For one point I wanted to make regarding 34(4). 34(4) is not a suo motu power which can be exercised by the court. It has to be a party applying. And in the Kinari case at para 14, I will not take this court's time, but my lords may make a note. And the Kinari Malik case at para 14, this aspect has been dealt with and pointed out. So, my lords, it is something where the court waits for one of the parties to exercise. But, my lords,
the language of the statute itself is very clear.
Yes. Yes, my lords, language is, that's why. So, that's why I'm saying that as far as 34(4) is concerned, it's a completely different genre. When we are talking about modifications to be carried out by exercise of powers by the court, my lord, that has to be traced under 34. My lord, that's my submission. Then, my lords, may kindly come to, so Kinari have dealt with, and my lords, finally, I would like to come to modern laminators, which my learned friend has already read out, Mr. Ritin Rai, that it has to be within the confines. And that confines, my lords, here I will comment one more submission. My lords had mentioned, may see 3.4 of my written submission, page 5. Learned Chief Justice had mentioned about section 15 of the Arbitration Act 1940. Now, of course, I'm aware that the case, I'm fully missed out there, but that case has said that section 15 provided for modification, etc., it's not there in the new act. But, my lords, when we look at the wider power of the court and the discretionary powers of the court, my lords, the contours of section 15 would be helpful guide in determining what should be the guardrails when the court is exercising its powers for modifying the award. And it has to be basically as what, my lords, I'm taking it from the words of the statute, basically a change, even if it's made, should not alter the basic structure of the award and the integrity of the award. This would constitute a legitimate modification under the act. And then, my lords, I made a reference to a Narayan Das case under the old act. And in that act, my lords, declaratory relief of ownership of property was given by the arbitrator without a consequential relief of possession. That's because the arbitrator was under the impression that the Bombay Rent Control Act applied and they would have to go to the Bombay Rent Control Act to take possession. That was found to be wrong, and under 15B, my lord, that was consequential relief was given, and they said, no, you can take possession. That's how it was interfered with. Then, my lords, the Pondicherry University case at 3.4.3, I've given an instance where a tribunal had not looked at the document at all. And so, my lords, it's not a reappreciation of evidence in that sense, my lords. It is looking at a document which has come, the court interfered there. And, my lords, my own case, my lords, 50 farmers for the last 15 years have been trying to seek compensation. This is under the NHAI Act. And, my lords, I would put it as a given case. What happens is this. It is accepted by both sides that there's a particular rate of compensation to be allowed. And when that rate is applied, unfortunately, the court says that, I'm sorry, the under 34, when the court applies that rate, it is set aside by the High Court, by the imbued order, saying you please go back by way of arbitration. There's no power to modify. Malad, those instances of injustice should be avoided. Malad, these are my respectful submissions.
I'm basically appearing in the NHAI Act. And our submission is, my lords, whenever a land is being taken away, Article 300 capital A say authority by law. The law has not only to be substantive in terms of adequate compensation, which is given, my lord, market value of the land, but the procedure established also must be due process. My lords, here what happens is that a competent officer is appointed, which is a SDM. The arbitrator is a collector. Now, my lords, I cannot ask for enhancement under section 34 when I go for the first time before a judicial authority. And my lords, both these my lords, sections are vulnerable. My lords, the virus is not a challenge. This court has held in the case of petroleum case, my lords, that a competent authority who is not legally trained cannot determine the compensation. Kindly just note, my lords, 2016-99 SEC. My lords, 2016-9 SEC 7-1. Perimeteria provisions. Competent authority determined, my lord, it was under the Petroleum Act, it is NHAI Act.
Yes,
And my lord, they have categorically stated that he should be a legally trained mind.
yes.
And my lord, they have struck down that if he is not a legally trained mind, he
But we are not dealing with striking down.
No, my lord, no, my lord, what we are saying is, my lord, a competent authority determines the compensation.
1 minute, how will we understand that, but we are not dealing with constitutionality.
No, my lord, I'm only pointing out. Then, my lord, arbitrator, kindly see CG 5, sorry, my lords.
The validity of 3G is under challenge itself.
Correct. My lord. All that I'm saying is the first time when we move to the court, my lords, it is before the district judge. Under, my lords, kindly see, the first time when we move before the district
We have
judge.
understood your argument that until unless you reach power of
Enhancement. Yes.
power of modification into 34, it can lead to a lot of injustice because the provisions of section 34 have been made applicable under various enactments where the common people, even public law remedies, which has been pointed out, Mr. Nafte, is applicable.
Therefore, my lord,
So therefore, while construing 34, we have to take into account their public law remedies also, which are named.
34 has to be read differently, my lord.
So
Whenever, my lord, a statutory
very well,
arbitration.
we examine whether it should be read separately or whether in 34 itself there is wider path. That's
Yes,
the one.
but because my lords, I should have a judicial forum for the first time.
They all argued by Mr. Rapne as well as Mr.
Well, my lord, all that we are saying is, well, he had the judicial forum is for the first
Anyone else? No.
And my lord, this very well. So, my lord, the procedure established by law must conform the due process of a fair judicial determination,
Okay,
unfettered by section 434 restrictions also.
okay, fine.
My lord, we should be able to provide the, my lords, and not relegate it back. Here also, my lords, rupees 50 was given. High Court has increased this to 10 times, my lord. Now,
Similar with Mr. Napne and Mr. Singh.
very well.
We have filed.
Now, call out the name one by one. Don't take it.
Shankar with Riddhi Nyati. This is for Shaft Shipyard, supporting the amendment. We have today opportunity to set right a problem that has been plaguing us for the last 10 years at least, which should have been done much before. Your Lordship has seen many litigants suffering. The choice is really to be made whether we drag our heels deeper into the existing problem on an imaginary obstacle under Section 5, or do we set right this opportunity which is today available. The Section 5, if my Lords may just see, Section 5 is not the obstacle, it's actually the gateway. The relevant lines my Lord reads is it says, shall intervene except where so provided in this part. That is a crucial part. Everybody has misread this to suggest that this is actually a limitation on the court's power. It says that when there is an opportunity, this is the window. Once you go inside, then there is no fetter as to what a court can do once it is faced with an award. So if my Lord may just see the last phrase under Section 5, it is not the obstacle, it's actually the opportunity for the court to set right this. That's our first submission, my Lord.
Yes.
Second is, we have to be careful with what we allow the court to amend in future. So without a doubt, it must be those where the tribunal did not have a discretion. So statutory rights not being enforced, contractual rights not being enforced. To that limited extent, necessarily there must be the power we submit to the court, not a very wide, all-encompassing position. Third is what happens when neither party has raised the objection about the court's power to amend or not to amend. And the court under 34 has gone on to amend that because both parties argued with a tacit consent that the power is there to amend. What happens to the fate of all those matters? Because those decrees under 34 are now, those orders under 34.
That can be squarely answered as far as court's jurisdiction is concerned. By consent, you cannot confer subject matter jurisdiction.
But what is happening is orders are being set aside on points that were never argued before. that.
Maybe.
That is one of the issues.
You can't confer subject matter jurisdiction where it doesn't exist.
Then-
Okay, we continue tomorrow, but within 25 minutes, whoever is there, please do not, only these names, one by one. And how much time, how many are there from the other side? Please, there are 4 of you?
4 or 5. I'll give rejoinder, my lord, not more than 25-30 minutes.
5.
4 or 5.
I have to start.
4 or 5 of us are there.
Okay, please now divide the time so that you end by 1 o'clock.
Just submit my compilation for one of the interviews.
Why are you submitting it now? And please sit down in the evening, make one compilation.
Yes, please, we'll do that. We'll ask.
They don't want multiple compilations.
We'll largely rely on,
Sit down in the evening, do one compilation. That's all. So 1 minute, whatever it is, make one compilation.
My lord, on this side, lordships, we have given a list. That list is there. That will be maintained as it is.
That
list
list
of
which
people.
is there will be maintained, but not more than 5 minutes. If anybody crosses that,
Yes.
he'll be eating into somebody else's time.
Keep your head.